Hello and welcome back to this video from the third unit of our course on fundamental rights in the Indian Constitution. In the last video, we had identified the important concepts and doctrines relating to Article 13 of the Constitution. Let's now understand one of the fundamental values of our Constitution, equality. Article 14 is the most important provision that guarantees equality. The importance of equality in the Constitution is underlined by the assertion in the preamble itself that the people of India have given the Constitution to themselves to secure an equal society. So, bearing that in mind, let us read Article 14. The state shall not deny to any person equality before law or the equal protection of laws within the territory of India. It is immediately clear that there are two separate guarantees in this article. The first is a guarantee of equality before the law. The second is that of equal protection of laws. What do these two phrases mean? We learnt in the first unit how the debates in the Constituent Assembly can help us interpret and understand constitutional provisions. Unfortunately, Article 14 is one of those articles on which there was very little debate in the Assembly. So, let us look at an earlier decision of the Supreme Court in State of West Bengal versus Anwar Ali Sarkar. Before we look at what the Supreme Court said, let us understand the facts of Anwar Ali Sarkar. The phenomenon of special courts is very common these days. Several offences, such as those investigated by the CBI or the National Investigation Authority, are tried only in special courts. In 1950, this was rare. The contention in Anwar Ali Sarkar was that Section 5 of the West Bengal Special Courts Act, which gave the state the power to send some cases for expedited trial to a special court, violated equality. The court found that the statute violated Article 14. B.N. Mukherjee, one of the judges who formed part of the majority, traced the origin of Article 14 to both the US Constitution and the unwritten English Constitution. But what do these guarantees mean? The court was clear that equality before law or equal protection of laws does not mean the laws must apply identically to everyone. This stands to reason. People, though fundamentally equal, are not similar in all respects. We know this from our daily lives. For instance, people have different physical or mental attributes. What Article 14 was understood to guarantee in the 1950s was a form of formal equality. That is, people of similar attributes or in similar circumstances must be treated alike. Therefore, it is open to the legislature or the executive to pick out a class of persons to whom a law or executive action would be applicable. However, such classes must not be arbitrarily created. The state must have found sound reasons for selecting a class of people as the target of state action. This is called the test of reasonable classification, where the court evaluates the reasons the state has for classifying people. Let us return to the facts of Anwar Ali Sarkar. There, the statute had given a reason for the power of the state government to direct offences to be tried by the special court, which was the speedier trial of such offences. The state contended that this was the basis of any classification which was to be made by the state. The court rejected the contention, noting that the reason given by the statute was insufficient. A word of caution though, the judgment in Anwar Ali Sarkar is not an authority for the proposition that the state cannot set up special courts. It all depends on the reasons supporting the classification. For instance, in Kathi Raning Rawat vs. State of Saurashtra, an ordinance, the Saurashtra State Public Safety Measures Ordinance of 1948, which set up special courts for certain offences, was upheld. The court was of the view that the ordinance provided clear reasons for the selection of certain offences for trial by special courts. The form of the test of reasonable classification is interesting. In several decisions of the Supreme Court, it is described as having three components. First, the classification must be based on an intelligible differentia. That is a complex way of saying that a class must be well defined. Persons or things included in a class must be distinguished from those left out. From the example of special courts, this component of the reasonable classification test refers to the class of offences or persons to be referred to the special court. Second, the object of the state action must be considered. In the special court example, the object of the state action is to ensure speedier trial. The third component of the test requires the court to evaluate the link between the first two. This component is called the rational nexus. From the examples we have seen so far, the court in Kati Rani Rawat found that there was a rational nexus between the classification and the object of speedy trial. In Anwar Ali Sarkar, the court did not find any strong reasoning to support the claim that some offences had to be tried by a special court. Following a number of decisions in the early years of the court, the test of reasonable classification became the primary method of evaluating whether state action is in line with Article 14. The Supreme Court has applied this test in many cases. By the 1960s, however, doubts were emerging whether this test was really sufficient. The real problems of inequality faced by citizens were not from classification or discrimination by legislation. It was due to discrimination by officials, that is, by the administration, rather than the executive or the legislature. For instance, consider a town planning law under which you are eligible to construct a house on a plot of land that you own. You apply to the concerned authority in the form that is prescribed by the law. You, however, get no response. Now, this is not due to a fault in the law. You belong to a class of persons eligible to build a house. It is the authority that has whimsically refused to approve your application. Chief Justice Subbarao, who authored several powerful dissents in the 60s, repeatedly warned that Article 14 should not be reduced to merely evaluating the classification made by statutes. In the 70s, the Supreme Court addressed this feeling of inadequacy arising from a restrained interpretation of Article 14. In E.P. Rayappa v. State of Tamil Nadu, a case relating to the transfer of a public servant, the court observed that equality offers a guarantee against arbitrariness of any kind. This formulation is called the new doctrine of equality as opposed to the old doctrine of classification. The major proponent of this version of equality was Justice P.N. Bhagwati, the author of the paragraph we just read from E.P. Rayappa. He affirmed this view in Menka Gandhi v. Union of India and in Ajay Hazia v. Khalid Mujib. Apart from the observations made in E.P. Rayappa, the Supreme Court has not really explained arbitrariness. A standard dictionary describes arbitrary as action based on random choice or personal whim rather than any reason or system.